हेलो फ्रेंड्स, वेलकम टू शॉर्ट हैंड विद विनय। ये डिक्टेशन 110 वर्ड्स पर मिनट पे होगी और इस डिक्टेशन का पैसेज प्लस जो टफेस्ट आउटलाइन है दोनों के लिंक डिस्क्रिप्शन बॉक्स में दिए गए हैं। आप वहाँ से डाउनलोड कर सकते हैं। तो चलिए स्टार्ट करते हैं। 3, 2, 1 स्टार्ट। द क्लेमेंट्स डैश अपीलेंट्स namely Dr. Anup Kumar Bhattacharya bracket start, who had unfortunately died during the pendency of the case before the tribunal bracket close, and Srimati Leena Bhattacharya, on 16/12/2004, instituted motor accident claim petition number -881/2004 before the tribunal, under section 166 of the Act, 1988, for grant of compensation on account of the unfortunate and tragic death of their son, namely Abhishek Bhattacharya, who had died in a motor vehicle accident on 20/07/2004, full stop. Dr. Anup Kumar Bhattacharya was claimant number 1, whereas Srimati Leena Bhattacharya was claimant number 2, bracket start. Dr. Anup Kumar Bhattacharya and Srimati Leena Bhattacharya shall herein after individually be referred to as claimant number 1 and claimant number 2 respectively, and jointly as within single inverted comma claimants, bracket close, full stop, para. As per the claim petition, the deceased was 24 years old and was in the final year of MBA course at the Institute of Cost and Financial Accountants of India, Hyderabad, full stop. It was also contended that the deceased was in the part-time employment of Messrs. IB Computech, Hyderabad, and was earning rupees 13,080, full stop. The case of the claimants, as a matter of fact, can be conveniently looked into in its entirety from the particulars furnished under the head, full stop. The claimants prayed for compensation of rupees 92 lakhs along with the interest at the rate of 18% per annum, as also the cost of the petition, full stop. They also prayed for an interim award of rupees 50,000 under section 140 of the Act, 1988, full stop, para. The claim petition was contested by the insurer, who was arrayed as opposite party number 1 in the claim petition, full stop. The insurer filed its written statement on 28/8/2005, full stop. The factum of the accident was disputed, the age of, income and occupation of the deceased was also disputed, the accident, if at all it took place, was alleged to have occurred due to the fault and negligence of the deceased and not because of the act of the driver of the offending truck, the dependency of the claimants on the deceased was disputed, the driver of the offending truck was alleged to have not holding a driving license at the time of the accident, the offending truck was alleged to have been driven in violation of the terms and conditions of the insurance policy, full stop. It, however, appears from the issues framed by the tribunal, which we shall refer to shortly, that not all objections taken in the written statement were pressed into service, full stop. The claimants adduced both documentary evidence and oral evidence to substantiate their claim, full stop, para. Issue number 1 and issue number 2 were decided together by the tribunal, full stop. The tribunal observed that the onus to prove the factum of the accident lay upon the claimants, whereas the onus to prove that there was contributory negligence on the part of the deceased lay on the insurer, full stop. As regards the factum of the accident, the tribunal held that since the insurer admitted that the accident did take place, factum of the accident stood proved, full stop. On the question if the accident was caused solely by the rash and negligent driving on the part of the driver of the offending truck or did negligence on the part of the deceased also played a role, the tribunal attributed the fault for the accident equally between both the deceased and the driver of the offending truck, full stop. The tribunal observed that the claimants did not examine actual eyewitness to prove the factum of the accident, while the insurer did not examine the driver of the offending truck to prove negligence on part of the deceased, full stop. It was, thus, reasonable to assume that both the deceased and the driver of the offending truck were equally at fault, full stop.